All right, good morning. Good morning. It's 8 a.m. and I'm going to go ahead and call this meeting to order. Welcome to House Labor, Health and Social Security or Social Services Committee. Members, good morning, welcome. And those of us joining in the public, good morning. Thank you for joining us. Mr. Caldwell or LSO staff, good morning. If you would call the roll.
Representative Clouston.
Here.
Representative Guggenmoss.
Here.
Representative Heft. Representative McCann.
Here.
Representative Ottman.
Here.
Representative Thayer.
Here.
Representative Wasserberger.
Here.
Representative Yen.
Here.
Chairman Rodriguez Williams. Madam Chairman, we have a quorum.
Oh, all right. If you did not notice on the outside of the room, we have rules of decorum and civility that we'll abide by during this meeting. So just a friendly reminder, committee, please silence your phones and members of the public as well. Just a few general decorum guidelines for those of us that are joining us in the audience and online. Committee members, speakers, and audience members will conduct themselves in a civil and respectful manner at all time during the legislative meeting. Speakers, please address all comments and questions to the chairman. Please refrain from using any individual names. Please direct your comments under the issue or directed to the issue under consideration. Testimony that strays from the topic will be called out of order. Please refrain from making comments of a personal nature that reflect upon the character or the conduct of a committee member or any other speakers. Any personal criticism, ridicule, or name calling is forbidden. So this morning we are going to hear two bills that we have in front of us. We'll hear Senate File 23 first, which is outpatient examination and commitment length. And then the second one, Senate File 57, transparency and hospital service pricing. So without further ado, we will place Senate File 23 on the table for the committee's consideration. And the sponsor of the bill is Senator Schuler. Good morning, Senator. Welcome. You'd state your name and walk us through your bill.
Thank you, Madam Chairman. Senator Schuler, Senate District 15. I'm happy to bring you this bill this morning. I want to apologize ahead of time. I woke up this morning at 4, couldn't go back to bed. I'm a little disheveled. I spilled gas on me when I was filling up my car. So if I smell like gas and I don't make any sense, I just apologize ahead of time. So sorry to all the rest of you too. Anyway, I bring you Senate File 23, outpatient and examination and commitment length. This bill was brought forward by a constituent, a judge over in my part of the county, who deals with the need to get timely examinations for those who need treatment with outpatient or inpatient care. What it does, it expands examiners from psychiatrists, physicians, and psychologists. It expands it to licensed physicians, assistants, and advanced practice registered nurses. Once a notice from the court is ordered for an examination of someone who's having some issues, it has to be conducted within 7 days from the date of the notice. And many of the smaller towns and cities in our state don't always have access to a psychologist or psychiatrist. And we're finding fewer and fewer physicians. And then quite often, some of them don't work 5 days a week, as we know. And so trying to get that examination done in a timely manner is causing some problems. What it ends up doing is leaving someone maybe in jail or at a hospital or at their home where they're maybe a danger to themselves, possibly, or someone else, waiting to get that examination. So the judge asked if we could take a look at expanding that. I know we have a lot more PAs and APRNs in our community, and I'm sure some of the rest of you are seeing that same thing. So what it does, it just expands that to those folks that can do that examination. And then once that examination is completed, the court can appoint any of those 5 people to do a further examination if indicated. So, and honestly, I've thought about this a lot. I went back and looked at the statute, and the statute basically says right now that even a social worker can do those examinations. Even a marriage and family counselor can do those examinations. So I really feel very confident in our PAs and our APRNs to be able to do these examinations. The most important point is if they don't feel comfortable, they can say no. So we did have an amendment in the Senate that was passed, which basically said, once they do the examination, then if a review is indicated, that we added some language over there and said that it had to be a licensed psychiatric mental health nurse practitioner over on page 2, and a licensed physician assistant with documented education, training, and experience in psychiatric or mental health assessment and diagnosis. And the Senate kind of felt comfortable in adding that because it is a big deal particularly if they're going to be sent to an outpatient, or excuse me, an inpatient facility. And so they just wanted to make sure that they had a little bit more training if they did the review. The exam, they felt more comfortable just leaving it as APRN and PA. Honestly, I don't think that the judge would probably ask one of those same people that did the examination to do the review. So, but the timeliness of getting that examination done in 7 days is really the big deal of this bill. I know the judge was having a hard time getting that and just felt bad that, we had people, particularly in our jails, that maybe just had a meltdown and they're sitting there waiting around to get an exam. And maybe it's just a situation where they need to have their meds changed or whatever. So I thought it was a timely bill, and I think that it's not just going to help us. I mean, obviously, we're an outlier over in Evanston because we have the state hospital there, and quite often some of our folks that get released, most of them stay in our community, and a good share of them do a good job, and they do fine. But there's some of them that maybe go off their meds or maybe go out and decide to party a little bit or whatever. And all of a sudden we have these situations where we need to have an examination taken place. So with that, I think that, excuse me, I think that pretty well explains the bill. I'm happy to answer questions.
Thank you. Committee, any questions about the bill for Senator Schuler? Representative Klauston.
Thank you, Madam Chair. Thank you, Senator Schuler. This is something we've dealt with in other issues, people sitting in jail for weeks waiting for an examination. My first question would be, how does telehealth fit into this?
Senator?
Madam Chairman and Representative Klauston, we talked about that a little bit. And I don't know of anyone that's using the telehealth for the examinations at this time, but I think it's something we probably should look at. I think it would be helpful. But right now, the way the bill states, it basically on page 2, if you look at that, the examination has to be at a hospital, a medical facility, or their home. So I assume that they could do it, the examiner from their facility, but I don't know of anybody that's done that yet. But I think that's something we should take a look at.
Follow-up, Representative Klauston?
Thank you, Madam Chair. And then again, thank you, Senator. My only other question with this bill, and what was the examiner piece, letting a marriage counselor commit someone. So just whether you can just assure me, or if somebody else in the crowd can assure me that this takes care of that issue.
Senator Schuler?
Madam Chairman and Representative Klauston, I believe it does. I think it specifies that it does expand a little bit, the number of examiners, but I think it specifies those 5 are the ones right now that we would feel most comfortable with doing the examinations.
Further questions, committee? Representative Yin?
Madam Chairman, thank you. Senator, appreciate the bill. I'm looking at the definition of examiner and which isn't in the bill. The bill doesn't include it, but it does include APRN and PA. So in addition to professional counselor or social worker or marriage therapist. So from my reading of the bill, putting this new language here basically says they don't need the secondary review. The APRN and PA don't need a secondary review. It doesn't really, it sounds like they were already included in examiner. They just don't need a secondary review on top of it. Is that correct?
Could you state? Sorry, Madam Chairman. Could you state that again? Representative,
So-
the last part of you, I couldn't quite hear what you said.
Madam Chairman, thank you. Sorry. So in the bill, we have these. So the first examination is lines 8 through 12, but there's a secondary examination that's triggered. Sorry. So it's conducted by an examiner other than a licensed physician. So this is describing what the trigger is for a second examination by the rest of the paragraph. And so the rest of the paragraph says, okay, if a marriage counselor had done the exam, then then you need the second review. But putting this language in lines 10 through 12 makes it sound like we basically are saying we already allow APRNs and PAs to be examiners, but now they just don't need to have the secondary review. Is that how you would see the bill as well?
Senator Schuler.
Madam Chairman, Representative Yin, no, that's not exactly how I see it. The bottom line is, yes, the marriage and family counselor could do a review right now, according to statute. I don't know of any of them that would do that. I don't know that they would feel comfortable. But just like an APRN or a PA, they could say no, of course. But if they chose to do one, then it would be those 5 people that would do the review. And if you take a look at, on page 2 of the very last line 19, it says if indicated. So the court may be just happy, you know, if a physician or a PA did the exam and they took a look at it, the judge could say, that looks good. I don't need the review. I don't think it's automatically triggered the way I read the bill. And who I've talked to, basically, they've said the same thing, that most of the time the judge will take a look at it, that the big thing is getting the exam done. But most of the time they'll take a look at it and say, no, this person, yeah, they need to just have their meds changed. They don't need to be, you know, put in the state hospital necessarily or a facility. So, but basically, yeah, if a review was indicated by the courts and the judge said, yeah, the marriage and family counselor did the exam, I probably should have a review by a physician or a PA or whomever. So I don't know if that answered your question, but.
Representative Gugumas.
Thank you, Madam Chair. Senator Schuler. I'm not really familiar with this process, but when a examination is ordered, how is that paid for?
Senator Schuler.
Madam Chairman, Representative Gugumas, I would assume the state pays for that, but
Okay.
that's a good question. I think there's probably somebody in the room back here that can answer that better than I.
Follow up,
Uh,
Representative Gugumas.
Thank you, Madam Chair. I guess my additional question would be if we are opening this up to inpatient facilities, would that therefore increase the cost of the examinations? So, question, thank you.
Senator Schuler.
Madam Chairman and Representative Gugumas, I would think not. But you know, the idea behind it really, I think, at least with the judge, when I visited with him about it, is to try and get help, get the examinations, get help to these people right away so that they don't become homeless or commit a crime or, you know, end up in the state hospital, to try and get them seen and examined and find out what their issues are. And so hopefully, probably a cost saving measure, quite honestly.
Representative McCann, did you have a question?
Thank you, Madam Chair. Just point of clarification, is this mainly pertaining to people who have, you know, been incarcerated?
Senator Schuler.
Madam Chairman, Representative McCann, no, sir, it could be anybody. You know, it could be someone just actually coming through town. We've had people, instances where sometimes they get off the bus, you know, from another state close to us and decide that they like Evanston and they stay there and then can't find a place to live and then, you know, get into mischief. And so it could be anybody. It could be a resident. It could be someone who's just coming into our state and into our county. But where we're seeing the majority of issues are folks that, quite frankly, have generally been in the state hospital and then been released. And sometimes, like I said, are doing well, and then they just kind of fall off the wagon for whatever reason and start to have some issues that affect everybody. So, but it could be anyone, you know, not necessarily the folks in the jails, but I think that's the judge's, that was his big concern, was that our jails were filling up with some of these folks that we just couldn't get the exams and couldn't get them the help we needed right away. So I think that's where it came from.
Follow up, Representative McCann.
Thank you, Madam Chair. So who would trigger this investigation, or I mean, can it be your neighbor and he just gets ticked off at you and decides he wants to screw around with you? That's what's jumping in my mind. So I want
Senator
to make sure we aren't doing that.
Madam Chairman and Representative McCann, generally it's because of a court issue. It's because they've been picked up by law enforcement for whatever reason. Maybe they've been in a fight, maybe they've created an issue, you know, in the community. So it's usually someone that's gone to our ER possibly, or has been sent to jail for whatever reason. So it's usually a court-ordered issue.
Committee, any additional questions for Senator Schuler? Representative Wasserberger.
Thank you.
Thank you, Madam Chair. Yeah, thank you, Senator Schuler, for presenting this with us today. Just looking at this part here at the end of the bill, on line 12 through line 17, it says a court shall, if these others, licensed practice, registered nurse, or a licensed physician assistant is not available, then the court shall appoint a licensed physician, psychiatrist, and then all the other ones included in there. So would all those be appointed to do this examination, or is it just, do we just need one person to do it? Just to get clarification. Thank you.
Senator Schuler.
Madam Chairman, Representative Wasserberger, really good question. No, it would just be one. And so once the court says we want to review these findings, he could choose a physician, he could choose an APRN, he could choose anyone on that list. So that's how that works.
Okay, any additional questions? Okay, thank you, Senator Schuler. Don't go far. Are there any government agencies that'd like to come forward? From Senate File 23. Good morning, Director.
Good morning, Madam Chairman, members of the committee. Stefan Johansson, Director for the Wyoming Department of Health. Just some brief comments as an overview on this bill. The way we see this in the Department of Health is you're trying to balance the ideal with the practical. And what I mean by that is when someone's going through the Title 25 process, the civil commitment process, those are folks who at any stage of that process are thought to be or could be dangerous to themselves or others and potentially in need of involuntary psychiatric care. It's a really big deal. When you're considering people's civil rights, that's why these discussions are so important. However, when individuals like that in your communities are being evaluated to determine if that standard is being met, ideally, we all want the highest level, most experienced psychiatric provider conducting those assessments. But we know in our communities, especially our small communities, that's not always possible. So you have to balance the practical. Who's available to conduct good, thorough, high-quality examinations to inform the court on that decision about civil commitment? And I think that's what this bill and what's been discussed in the past is who should those providers be that can conduct and those evaluations and make those recommendations to the court. To give the committee a little bit of a summary of the Title 25 process, and some of the questions were related to that. The way that this works is if someone in your community is potentially having an episode, mental health issue, et cetera, often first contact will be law enforcement, responding to a call either from that person, their family, or a member of the community that there might be an issue. Or in some cases, a person who presents at the emergency department could be a variety of issues, but there's a suspicion that a psychiatric or a mental illness might be at play. And what can happen there is that law enforcement or the emergency department can do what's called an initial emergency detention. You'll hear this term from your county attorneys, your judges. It's called a 381 form. A form is filled out that there's suspicion that maybe there's a serious psychiatric issue going on. An initial detention, basically a 24-hour detention, can be issued through the county attorney. Within a very specified amount of time, a hearing must be held for a judge to determine if continued detention should be ordered. And if you go through Title 25 statute, what you see here in the bill is amending Section 110. Prior to that, in Section 109 is that continued detention, which can be issued for up to 10 days. That's really the period that I think is in question here when an additional examination might be occurring to determine then at the 110 level in Section 110 of this statute, if ultimately an involuntary hospitalization, a civil commitment, will be ordered. So prior to that are when these examinations happen. In that first stage that I mentioned, emergency detention, that's where, as was discussed earlier, there's a variety of different types of providers that are listed in statute that can conduct that initial evaluation. And that is what is determining a recommendation for emergency detention or continued detention. So assume that happens and that detention is issued by the court, that continued detention for up to 10 days. Then if that initial examination was conducted by one of those types of providers that's listed in a previous section of statute, is going to be used to determine the ultimate involuntary hospitalization order, then a secondary review or a secondary examination is needed. And in current statute, it's by a physician, a psychiatrist, or a licensed psychologist. This, again, bringing in the practical for some communities that may not have access all the time to those types of providers, can allow an additional level of provider to conduct that examination to determine involuntary hospitalization. And in this case, an advanced practice registered nurse, and as you see here, lines 14 through 17, licensed psychiatric mental health nurse practitioner, a licensed physician assistant with documented education, training, and experience in psychiatric or mental health assessment and diagnosis is that next level of provider that would be added. And again, Madam Chairman, members of the committee, this has been discussed quite a bit over the years, and I think it makes sense on the practical side to allow communities and judges that option to have that type of level of care, that level of provider. If the judge trusts it, and again, this all rests with the judge to make that ultimate decision based on all of the evidence, examinations, review of the materials. If someone's civil rights should be stripped and essentially committed to psychiatric level of care, generally at our state hospital. So again, it's a significant issue, but we at the Department of Health see this as that balancing act, that as current statute contemplates, you really don't want a broad array of providers, even if allowed to do those initial examinations for those initial proceedings of Title 25. Because this is a civil rights issue, you really want as many layers and professional practice as possible, because that decision is so grave and so serious. And our reading of this bill, my reading of this bill, is that it does strike that balance, but we have to, at the Department of Health, with our experience in psychiatric medicine, urge that caution that the broader this gets, the more civil rights issues you could have with folks being put onto those waiting lists for Title 25, commitment to the state hospital, et cetera. However, with the Senate amendment that you see here that Senator Schuler rightfully mentioned, I think there's enough protection here to add this as a tool to the court. But obviously in these proceedings, any judge, any court is going to want to have the best information possible. So a physician's assistant that has that training in mental health, a psychiatric nurse practitioner, we employ many of those at the state hospital. These are great providers with good experience in mental health and psychiatric issues. So I think that's the underlying goal here, that the balance really needs to be struck in that direction, because this is not just about access to mental health providers, which Wyoming struggles with. We have health provider shortages in a lot of different areas. But this also involves that legal system and legal process where society and at the county level is really determining if someone's rights temporarily should be stripped away because they're in such desperate need of psychiatric help. And that's the service that we at the state hospital provide. So again, Madam Chairman, we take this very seriously, appreciate the dialogue, the amendment that happened on the Senate to try to strike that balance. And finally, Madam Chairman, if I may address Representative Guggenmoss's question on cost. In Title 25 statute is very specific that the county that's originating that emergency detention in Title 25 proceedings is responsible for all costs of detention in the first 72 hours of that process. After that 72-hour process is when the Department of Health shall be the financing mechanism for that, for treatment. And we do that through agreements and payments with designated hospitals or other providers that might be involved, like emergency departments, folks who are being held awaiting admission to a higher level of care, a psychiatric bed. That's where the department would take over those costs. So it's kind of a blend. And as Senator Schuler mentioned, the volume of civil commitments is already there. You can assume that that's static. It's definitely variable month to month, year to year, because it's more of a reactive type of law. These folks, you can't really predict when they'll present and how many you'll have in a county in any given month or year. But statute is pretty clear that it's kind of a blended approach on who's responsible for those costs, really shared in the short term between the county, and then after those first 72 hours plus weekends and legal holidays, the state. But before the involuntary commitment proceedings that you see in this section of statutes, the final section 110, where that final hearing is being held to determine hospitalization or not, there's usually about 10 to 14 days prior to that can happen before that involuntary hospitalization is ordered. And that's really what a tool is being added to this section, but it's really informed by those prior sections of how was this evaluation or examination initially conducted and what level of review is needed beyond that. Madam Chairman, kind of a meandering, long-winded explanation. More than happy to answer any questions on sort of a complicated civil and mental health process. But again, we believe that given the realities of some of our communities, additional practitioners with that experience, with that training, could be useful to your courts in conducting these examinations in a more timely manner. Happy to stand for any questions, Madam Chairman.
Thank you, Director. Director, is there anything in the bill that precludes use of telehealth? Can you touch on the question that was raised from the committee?
Madam Chairman,
telehealth?
thank you. It's not directed, but it's certainly permitted. And so both in Title 25 and Title 7, there's been discussions around folks in jails, et cetera. Generally with your incarcerated population or folks who are pretrial detainees, that's a different process. Can lead to the state hospital, but that's on the criminal and forensic side through Title 7. In Title 25, these examinations, any treatment that's happening prior to admission to the state hospital can absolutely include telehealth. Now it's variable across your communities of when that happens, how that happens, and really is dependent on the client. But there's nothing in Title 25 statute that would prohibit that use. So presumably you could have an examination conducted via telepsychiatry. But it's not as widely used at this point in Wyoming, but certainly a possibility.
Thank you, Director. Committee, any questions of the Director? Representative Yen.
Madam Chairman, thank you. Director, thank you for helping us understand that, an involuntary commitment is essentially taking away someone's rights, and so there should be a high bar. I'm curious, one, you heard the question that I asked Senator Schuler, so that, and I'm a little uncomfortable to keep making it as wide as every PA and every APRN. Would you be okay if we did use the same language in lines 13 through 17 to put into those lines 10 through 12?
Director Johansson.
Madam Chairman, Representative Yin, it's a really good question. I think it kind of in my view, a policy call for the legislature to, as you mentioned, determine that if essentially that initial examination was conducted by, let's take current statute, an examiner other than a licensed physician, a licensed psychiatrist, or a licensed psychologist, current statute then triggers a secondary review by a licensed physician, psychiatrist, or clinical psychologist. What this would do, as you mentioned in lines 14 through 17, add that those two secondary or alternative options, a psychiatric APRN or a physician's assistant with that training. A couple of options as I see it, Representative Yen. One, the red language on lines 10 through 12 could be reverted back to current statute with 14 through 17 remaining in this bill. That would essentially say if a licensed physician, psychiatrist, or psychologist did not conduct that initial examination, then the list on lines 14 through 17 would be that secondary evaluation or secondary review. So that's one option to essentially clean up the issue that you're talking about. However, it's a policy call that in that initial examination, does the legislature believe it's prudent to say a licensed psychiatrist, a licensed APRN, a licensed physician's assistant, or a licensed psychologist can conduct that initial examination? And if so, the court does not need to order that secondary review. Again, that's the balancing act here of what is highly variable in your communities and really up to the judge to determine, was that initial examination sufficient enough for us to make this decision, for me as a judge to make this decision on civil commitment. In some cases, I think that would absolutely be the case. In others, it's important to remember a judge absolutely still has the ability to order secondary examinations if that initial evaluation or examination was not sufficient enough. So Representative Yin, I know that's again, a meandering answer. These are tough issues, but I certainly see some options there depending on the will of the legislature.
Director, just a follow-up question from Representative Yins. While we're looking at lines 12, the end of line 12, it states the court shall appoint a licensed physician, comma, a licensed psychiatrist. And just to piggyback on Representative Wasserberger's question regarding the use of punctuation there, do you foresee the need for cleanup? It kind of makes it look like all of the above shall be appointed.
Madam Chairman, just looking at that now, I would certainly defer to LSO legal on necessary punctuation depending on the intent of the legislature. And it reminds me of the infamous comma bill that we brought to the legislature at one point in time that was striking a comma because it could change the intent of the sentence. But Madam Chairman, I would defer to LSO there.
Thank you for your feedback, Director. Committee, any additional questions of Director Johansson? Representative Thayer? No? Okay. All right. Okay, seeing none, thank you. Any additional government agencies that would like to testify? Okay, seeing none, we'll go ahead and open it up for public comment. Raise your hand if you plan on testifying on this bill. Okay, just a lot of spectators. Exciting. Okay, we'll open it up for public comment. If you'd like to give your opinion on Senate File 23, we'd love to hear it. Okay, see none. Mr. Caldwell, is there anybody online? All right. All right, I will close public comment on Senate File 23. Committee, what is your pleasure? Okay, the bill has been moved by Representative Heft. Second by Representative Clouston. Discussion and amendments. Representative Clouston.
Thank you, Madam Chair. So towards our previous discussion on punctuation, I'm looking at page 2, line 13. After the word appoint, add one of the following colon. Because right now it does look like the court shall appoint a licensed physician, a licensed psychiatrist, a licensed psychiatric mental health, and go on from there. It sounds like you have to appoint a team. So, or you can just do the licensed psychologist and skip the team. But, so yeah, I'd like that would be the amendment. Add one of the following after appoint.
Okay, so there's been a motion made on the grammar or the punctuation, and it's been seconded by Representative Gugamas. And Mr. Caldwell, you have that conceptual amendment for us?
Just to, if I could just repeat back
Please.
the amendment. So that would be page 2 at line 13, after the word appoint, just inserting one of the following colon to make it a list effectively. So it would read, the court shall appoint one of the following. Thank you.
Great discussion on the amendment. See no discussion, question being called by a voice vote and a show of hands. All those in favor of Representative Clouston's amendment, state aye. Aye. All opposed? Okay, that amendment has passed. Further amendments, further discussion. Representative Heft.
Thank you, Madam Chairwoman. Line 7, page 2. I would propose strike the word his and add the patient's.
Second.
Okay. On page 2, line 7, in lieu of the word his, replace it with the patients. We have a motion and a second by Representative Gugamas. Mr. Caldwell, you have that? Okay. I do, excuse me, I invite Senator Schuler to come up. If you have any feedback on any of the proposed amendments, you're welcome to chime in. So, all right. Committee, any discussion on the proposed amendment? Representative Yin.
Madam Chairman, thank you. I mean, I don't think it has any ill effect, but I don't want to mess too much with involuntary commitments if we don't have to on the parts that no one seems to have issue with. So probably we'll vote no just because I don't think we need to change it, but I don't think it hurts.
Kate, and is the director still in here? Director, if you'd come up. Just while we're on discussion of the amendment, I'm just curious if any similar language is used like this in Title 25 or not.
Madam Chairman, Wyoming statute is notorious for using he and his throughout, referring to persons. So as Representative Ian mentioned, certainly doesn't hurt, but it's not conforming with the rest of statute necessarily. Again, easy punt here, would defer to LSO legal there, but certainly the intent is there. Patient is mentioned in the previous part of the sentence, so it still reads fine.
Thank you, Director. Further discussion on the amendments? Okay, seeing none. By a voice vote and a show of hands, all those in favor of Representative Heff's amendment, please state aye.
Aye.
All opposed? Okay, that amendment has passed. Further amendments, further discussion on the bill. Representative Yin.
Madam Chairman, thank you. I'll move to replace the language on page 2, lines 10 through 12, the new language. So a licensed APRN, a licensed PA, with the same language from lines 13 through 17. A licensed psychiatric mental health nurse practitioner, a licensed PA with a documented education, training, experience in psychiatric or mental health assessment and diagnosis.
Okay, we have a motion. Is there a second? Okay, seeing none, the motion has failed due to lack of a second. Further amendments, further discussion. Question being called on Senate File 23. Mr. Caldwell, if you call the roll.
This is a roll call vote for Senate File 23 as amended. Representative Clouston,
Aye.
Representative Guggenmoss,
Aye.
Representative Heft, Representative McCann,
Aye.
Representative Ottman,
Aye.
Representative Thayer, Representative Wasserberger, Representative Yen.
Aye.
Chairman Rodriguez Williams. Madam Chairman, that is 9 ayes.
Senate File 23 has passed, and Senator Schuler, if you find somebody to carry your bill on the House side, that'd be great. Thanks for joining us. All right, we will move on to Senate File 57, Transparency in Hospital Service Pricing. We'll place that bill now on the table for the committee's consideration. And this bill is sponsored by Senator Brennan. If she is here. Okay, so we'll just stand at ease for a minute until she comes. All right, we will go ahead and move forward with the meeting. Again, Senate File 57, Transparency and Hospital Service Pricing is on the now on the table for the committee's consideration. Good morning and welcome, Senator Brennan. If you would talk to us and walk us through your bill, that'd be great.
I will. Thank you, Chairman Rodriguez-Williams, members of the committee. Thank you for your patience. We're having a hard time keeping a quorum in my other committee meeting this morning. So thank you for considering this bill. This is transparency in hospital service pricing. There was a bill that moved through both bodies. This should look familiar in a lot of ways from that was moved through both bodies last year. But with that bill, there was some things that were very problematic. So this interim took this bill, worked it, really keeping the meat and the potatoes of the bill. Because we all know that hospital pricing and that transparency piece, that's important to us and to our communities. I think we all have stories of that hospital pricing and getting a bill and you're going, what on earth is this and why was it this cost? Even I myself, who can navigate our complex medical system relatively well, has stories of the difficulties of that. So I will go ahead. That's why we bring you this bill, because this is an important issue. It needs to really work for everybody. So with that, I will just walk you through the bill. On the first page, we have the title of the bill, our purpose of the bill, and then we go on to page 2 and starting, I will read on pages 2, lines 5 and 6, well, through 10. This act shall be known and may be cited as the Hospital Price Transparency Act. And then this really sums up the bill nicely. The purpose of this act is to require hospitals to close prices for certain items and services and to provide civil penalties. And then we go on, starting in lines 14 on page 2, excuse me, through lines page 5, I do believe. Yes. This is all just definitions. And so I will not bore you guys with definitions, but that's what we have going through here. And then on page 6, line 4, this is going to give directions on what standard charges the hospitals must keep and how those are kept and how they are searchable. So this gives direction to the hospitals on what to do. I will note too that there is a lot of federal law already in place around this issue, and this bill really seeks to mirror that federal law as much as possible so that we're not having conflicting federal rules with state law. If you go over then to page 10 of the bill, this is going to allow the Department of Health to monitor the compliance with this law. On page 11, we give a corrective action plan to the hospitals. And I will note that this is modeled off of what hospitals currently have that they have to follow. So there are different places that can come in when a patient has a complaint with a hospital. They can complain to CMS, the Centers for Medicare and Medicaid, and they can come in and do a review of whatever that is at the hospital. And then there's also some hospitals will pay a big fee to other places that will come in that will survey the hospital, and those complaints can be filed, or sometimes in those surveys, things are found to be wrong. When those surveys happen and something is found to be out of compliance, a hospital is given the ability to do what is called a corrective action plan. And so we have modeled this after that, telling the hospitals you have to come up with a corrective action plan, you have to submit that and do those. But then if you don't, then we go to page 13 where we have the civil penalties for that violation. Page 14, starting on lines 20. Then we have where the department may propose the legislature any necessary recommendations for amending this act. And I think this is important since federally this has been moving and changing and we're seeing different things and this is kind of a new process. And so we want to make sure that this is working, and especially for our citizens, that they're able to find this price transparency. And so this just tells the department that, you know, if you find some things, come back to the legislator and let us know what to be able to be done. And then page 15, this outlines the conditions and gives the Department of Health the ability to revoke a license. And then in section 3, we give the department ability to promulgate any necessary rules. And then this goes into effect July 1, except for sections 3 and 4. I will note that this was amended over in the Senate to be repealed. It gives a sunset date over in the Senate that was put on. And the thought there from the bringer of that is that this is changing, and if we put a sunset date on it, this forces the legislature to come back and make any changes to this legislation to in the future as things are changing. And as we know, medicine and medical stuff is always changing, so that we can look at it, make sure that this is working, what is and isn't. And with that, Madam Chairman, I will stand for any questions.
Thank you, Senator. Committee, any questions? Representative Clouston.
Thank you, Madam Chair. Thank you, Senator, and thanks for being here. I was afraid I was gonna have to try to present this little 16-page bill. Question, in your discussions with the facilities, effective July 1st, are they able to comply with that date, or is that, okay, thank you.
Yeah,
Senator Brennan?
and they can correct me if I'm wrong, but really a lot of this stuff is already in place because there are strict federal guidelines that they are already adhering to and coming in compliance with. And I think that I hope that the hospitals and facilities, there's actually some really interesting numbers on how many facilities have been out of compliance. And as these laws have been in place, that there's fewer and fewer, and that a lot of our hospitals and facilities are doing this. We're just codifying it.
Additional questions, committee? Representative Wasserberger.
Thank you, Madam Chair, and thank you, Senator Brennan, for presenting this bill today. Would this just only apply to the hospital? So if if you wanted to go to like a dermatologist clinic and, you know, for a skin treatment, would they be expected to have that hospital pricing transparency for, say, like a mole removal? Or is it just, would it only apply to your hospitals? Thank you.
Senator Brennan.
It's, yeah, it is hospitals. This does not include like your doctor's offices and those visits.
Additional questions? Representative Yin.
Madam Chairman, thank you. Senator Brennan, is there any, you know, sometimes in these things where we have both a federal law and a state law, we say federal law presides. Is there any clause like that in this bill at the moment?
Senator Brennan.
Thank you, Madam Chairman, Representative Yin. No, there's nothing that spells out, I don't believe that spells out that federal law would be what we would defer to in this. I think that that is something that I would be amenable to looking at so that there's not that confusion.
Further questions? Okay, seeing none, thank you.
May I,
Sure.
Madam Chairman, make one more comment on this? Representative Wasserberger's question kind of led me to, What this doesn't do, this is like hospital pricing. This doesn't, there's still that insurance piece where people who have insurance, a lot of what they pay after their out of pocket, their deductible is met, is gonna be determined still by like their co-pays and things like that. This doesn't contemplate any of that stuff in the bill. You still have the insurance piece to work with.
Thank you. All right. Oh, we do have another question. Representative Clauston.
Thank you, Madam Chair. Thank you, Senator. So in the definition here, it talks about require hospitals. So in Wyoming, we do have different types of hospitals. Does this include all types? So I'm thinking like some of our inpatient rehab are considered hospitals. You know, we have long-term care facilities attached to hospitals. Maybe some of the behavioral health units, I mean, I think are considered hospitals. So I don't know if you want to phone a friend or if you have the answers, but just curious on who's all affected.
Senator Brennan.
Thank you, Chairman, Representative Clauston. Could you reference the page that you're on? I don't have this 16-page bill completely memorized.
Representative Clauston.
Thank you, Madam Chair. You know, so in the title, it says transparency in hospital services, pricing. And when I go to page 2, line 8, under B, it says the purpose of this act is to require hospitals. And I just want to know, are we trying to look at a certain type of hospitals? Or are we going to include all hospitals in Wyoming? Because we might have some unintended consequences here.
No, thank
Senator
you
Brennan?
for that. Thank you, Chairman and Representative Clauston. I do believe that the answer is on page 3, line 9, where we say facility means a hospital located within the state and licensed under Title 35, Chapter 2, Article 9 of the Wyoming statute. And I can't quote that one for you, but I have some friends that can answer that question more thoroughly.
All right. Okay, seeing no further questions, thank you. Are there any government agencies that would like to come forward? Good morning. If you'd state your name and your take on the bill.
Morning, Madam Chairman, members of the committee. My name is Franz Fuchs, Deputy Director of the Department of Health. We don't have any specific comments on this bill, just happy to stand for any questions. Madam Chairman, regarding Representative Clauston's question, it does, as Chairman Brennan indicated, you know, that Title 35, Chapter 2, Article 9 definition of a hospital does include psychiatric and rehabilitative hospitals as well as acute care hospitals. So if it's up to the will of the legislature to modify that, then that would likely help us figure out exactly who we should be regulating.
Thank you. Representative Wasserberg, you have a question.
Thank you, Madam Chair. Yeah, thank you for coming and helping clarify some questions. I was just wondering if this would also, if you're in an emergency situation where somebody has to dial 911 and have the ambulance come in, do they let you know the pricing on the hospital on your ambulance trip when somebody's cognitive to be able to know that information? Or is that, how does that work when you have those emergency response actions?
Mr. Fuchs.
Madam Chairman, Representative Wasserberger, I think the intent of this bill is really for more shoppable type services and not for emergency services. I think, you know, there would be some charges that would be listed on their website that might pertain to emergency room visits or other emergency type services that are beyond the shoppable services. So if someone was in an ambulance and they wanted to look up the price on their phone or something, I suppose that's possible, but I don't think there's any requirement here for the hospital to provide that list of someone who's being transported.
Committee, any additional questions? Representative Clauston.
Thank you, Madam Chair. Thank you, Mr. Fuchs. So going back to my question with that statute and then looking at what the federal government currently requires. Are we adding facilities in this by putting in our statute here that the federal requirements are not requiring for hospital transparency?
Mr. Fuchs.
Madam Chairman, Representative Clausen, I'm actually not entirely sure whether or not the federal requirements apply to psychiatric or rehabilitative hospitals. I would imagine they go through the Medicare conditions of participation. That we can try to get an answer back to you.
Additional questions, committee? Okay, Mr. Fuchs, on page 15, section 3, it states that the Department of Health shall promulgate all rules necessary to implement this act. Being that this act only is effective until 2029, would those be temporary rules or permanent rules? And what type of rules do you foresee being promulgated?
Madam Chairman, we would likely do regular rules, and those rules would expire with the sunset date. Typically, we only do either emergency rules or regular rules. And so we would likely have the time to develop regular rules and do that promulgation procedure and not need emergency rules in this case.
Thank you. Follow up, Representative Clauston.
Thank you, Madam Chair. Thank you, Mr. Fuchs. So is the July 1st date reasonable, or are we going to need some more time for that? Thank you.
Mr. Fuchs.
Madam Chairman, Representative Clausen, I think that's a reasonable date. What's contemplated in here for enforcement is very much in line of what we do with regular surveys. Really is kind of looking at websites. We can do a lot of this remotely. I don't think this will be too complex for us.
Further questions, committee? Okay, seeing none, sir, thank you for joining us this morning. Any other government agencies? Okay, seeing none, we'll open it up for public comment. Raise your hand if you plan on testifying. Okay, perfect. Come on up. Good morning, sir. If you'd state your name and we'll hear your take on the bill.
Good morning, Madam Chair, members of the Labor Committee. Happy Friday to you. My name is Jeff Darty. I am here today representing Cicero Action. I will be brief in my comments since it looks like you've got a lot of business ahead of you. But I just wanted to point out that in my view, I think one of the biggest problems in healthcare is a lack of a cost-conscious consumer. And one of the reasons for that is it's really hard to be informed about costs. And so my hope in supporting this bill today is to give Wyoming families and workers the same clear pricing information that you might expect when you go to buy a car, when you go to the grocery store. And I know that things can happen in the course of medical treatment that aren't anticipated that are going to change your cost. But to the extent that we can really lay out a clear way for our consumers to shop pricing is a massive step in my mind in the right direction. Madam Chair, I'll tell you that in a previous life, I worked in a community on the west side of the state, has a couple national parks in it, but they have, my employer at the time, for example, MRIs. MRIs were twice as expensive in the community that I lived in versus Idaho Falls, which was an hour and a half away. My employer paid me mileage, and I can't swear to the second thing I'm about to say under oath, but I'm pretty sure they actually gave me a percentage of the savings if I would take the hour and a half and drive to Idaho Falls. And so it was worth it. I did it. And I think through bills like this, we can create cost-conscious consumers that are going to go out and make those sorts of decisions. And committee, one of the challenges is even within hospital pricing, as my venerated colleagues to my right here will tell you in a minute, they have different price schedules. Medicaid, a high price schedule, a low price schedule. Pricing varies in network, out of network, and it's really hard for people to become informed. So, Madam Chair, I think this is a positive step in the right direction. Again, not a silver bullet, but I want to be clear. I'm so grateful for the two people seated next to me who have been collaborative on this issue and helping us get to a successful conclusion. So I'll leave you with this. This isn't about punishing our good friends at the hospitals here. It's about restoring accountability, patient choice in a system where financial uncertainty is all too common. Happy to stand for questions.
Thank you. Committee, any questions of Mr. Daugherty?
Thank you.
Okay, seeing none, thank you for joining us this morning. Sir, if you'd state your name and we'll hear your take on the bill.
Madam Chairman, committee members, for those of you that don't know me, I'm Eric Bully, President of the Wyoming Hospital Association.
Good morning, Madam Chairwoman, members of the committee, Kelsey Prestisator with the Wyoming Hospital Association.
And Madam Chairman, before we even start this, I just want to thank you for bringing that amendment on Senate File 4 yesterday. I think it really strengthens the EMS bill, so appreciate that. So in regards to this bill, we stand in support of it. We actually worked very closely with Senator Brennan through most of the interim. What I would say is most of you probably remember this debate from last year. And when this bill was presented, we hadn't been made aware of it. We had no chance to react to it. We had no time to talk about the ramifications or what it might do. We were also going through changes. And what I would say is that in President Trump's first term, right towards the end of his first term, he enacted an executive order that started this whole hospital pricing transparency process. During the Biden administration, there were 2 changes to the program. And then if you remember last year, President Trump had just come back in for a second term. And literally while we were in session last year in February, he started changing the rules. And one question that came up, and one reason I think this is important, but I also think the question that was asked about whether or not we could get into conflict between federal and state and who is supreme in that. Right now, this is done under rule federally. It's not done under law. Congress hasn't acted on this. And so it's all done through executive order, which creates an amount of uncertainty because there are a lot of executive orders have been signed lately and over the last several years. So we do think this will codify into place what is existing currently. And the reason I think it's so good that we waited is because things changed again since last February. And we're currently under a brand new requirement. And this bill is mirrored on the exact rules that are in place right now federally. And so it gave us time to do that. I'll also let you know that our hospitals just went through training on this. There was a webinar that was held not too long ago by a national group to train us on this. And they told us that the new rules were supposed to be enacted January 1st, but there are some problems. There's some problems with programming and getting systems up to speed and interpretations of the executive order. And so that has been delayed until April 1st to give the feds a chance to kind of get things in order and to give us a chance to adapt to what's required. So this is the latest, greatest version of what's going on federally. And so I think that timing was very, very good. And I think both Senator Brennan and Mr. Daugherty did a great job of talking about the fact that this is only part of the equation. Consumers do have the right to know what prices are. What you need to realize, though, is in this bill, these are estimates. These are best guess estimates, and it's the top 300 charges on everyone's charge master, if they even have those, but it's the most common charges. And they're estimates because things change. It's instead of buying a car, let's talk about repairing our car. So when we go in and get our car repaired, we may think that we have one problem, and then all of a sudden our buddies walk out and say, hey, listen, you need to have these filters changed. You need to have this, whatever, this fluid changed. Or there's a whole nother problem. Your tie rod ends are broken or U joints are out. And so all of a sudden, what you thought was a simple repair becomes more complex. That happens in healthcare too. And I'll share a quick experience. I think I did last year, but when I don't know, my wife and I were just barely married. I was playing basketball. I hurt my knee playing basketball, heard a loud pop. Went to the orthopedic surgeon and they looked at it. They did all their tests and everything and said, we need to have you come in and do a meniscus repair. We're going to go in and trim the meniscus because you got a meniscus scare. So I went in to the operation. I knew that the operation was supposed to take an hour and a half. And so 5 hours later, when they brought me out of anesthesia, I'm freaking out. And my wife had to come in and hold me down on the bed because I knew something had gone wrong. Well, when they got in there, they realized not only was the meniscus damaged, but my ACL had ruptured. It was gone. And so when I woke up, I had a cadaver ligament, as in my new ACL. That happens all the time. When we're talking about hearts, I can tell you a story about my CFO whose wife just went through open heart surgery. Things change. And so these are estimates, but we can't be held 100% to those. And that needs to be realized going in. The other part of the equation, and I think they touched on it, is this is only one part. This is the pricing, but what patients actually pay has a lot to do with the insurance companies. And there's work right now federally to bring them into the equation and make them part of this. But there's really no requirements for them to be as transparent in this and help. And we've talked and we've worked on bills in the past that had to do with prior authorizations and determinations and all those things. But you can get an estimate, but how it gets paid is really on the insurance side of things. And this also addresses uninsured, underinsured, sliding fee schedules, having that readily available to our patients. We work with them already. We have financial managers that sit down, and if they're going to have a surgery, we can walk through and look at their income and work off of federal poverty guidelines and things to give discounts and all of that. We already do those things. And so this is only one small part of the equation. Our hospitals are already actively participating in this, and we testified to this last year. And I don't know if any of you did this, but I actually challenged y'all to go and look at your hospital websites and see if your hospitals are doing this. We have queried our members as we've been going through this, and I am aware of one hospital that's out of compliance. And the problem is that their programmers are having problems. They're a smaller company and a smaller hospital with very few resources, having a hard time coming up to speed, up to snuff. And they will tell you that because their programming company, their software company can't be in compliance, they'll be out of compliance with the new regulations because it's going to take about 120 days for them to change that platform. One of our small hospitals in the Bighorn Basin shared with me that they've been actively participating in this since the beginning. Their site, and they have the ability to track this, has been accessed 7 times in 5 years. Of those 7 accesses, 5 of those were done by their HIM, their internal integration manager. So 2 other times. We can't tell for sure who was that. But with that said, let me tell you, it cost them $40,000 to implement this program. And it costs them about $3,500 a month to keep this going. This is an unfunded mandate. There is no talk of ever paying for this, even though it's federally required. And so that's just one of our smallest hospitals. And we've talked about the financial fragility of our hospitals right now. There was a Becker's report that came out yesterday, and it reported 743 small hospital closures around the country in the last year. It also showed Wyoming, and it showed that there are 6 hospitals that are in immediate jeopardy and 3 that are under threat of immediate closure. We have hospitals that have 3 to 5 days cash on hand to operate $1 million organizations. So where is the money supposed to come from? Do they pay the $3,500 a month or the $40K to get this thing stood up? Or do they pay payroll? Do they pay their doctors? Do they pay their accounts payable? We're doing all we can. We think we're being good partners in this, but I just think it's important that everyone knows that that's where we're at. I would also tell you that we're aware the insurance companies are using this as a tool. So who's accessing this company? The insurance companies are. They're going in and they're mining data, and they're using that data to then go and use that to put the screws to our hospitals and to drive down what they're willing to pay under their contractual allowances. So we think that they need to be part of the solution, and we would hope that federally there will be some rules that will be coming, and then maybe we can do something on the statewide. In context of the bill, I think Senator Brennan did a great job, but let me just explain this to you really quickly. The way that we've crafted this is very similar to the way that the feds enforce this. So our hospitals, our critical access hospitals, have to be surveyed by the state every 3 years. Nursing homes have to be surveyed by the state every year. Our bigger hospitals actually pay $20,000 to $40,000 a year to be surveyed by an outside agency, but they have to do that every 3 years. And when they're found out of compliance, the Department of Health issues them a survey finding and tells them what's out of compliance. They then have time to reply with a plan of correction that is accepted by the Department of Health, and they have a certain period of time to bring everything into compliance. With that done, there are no penalties that are levied. Now, if they are out of compliance after that 45-day period, there are remedies, and it can have anything to do with admissions, payments, or fines. Similarly, under the federal rules, that's how the feds have operated. And Senator Brennan alluded to this, but I just wanted to share, this came from that training that we had. So in 2021 is when this started, and it was slow to get started because there were software companies that were scrambling to meet the requirements. There were out of all the hospitals in the United States, there were 3,269 hospitals that were found to be out of compliance. Out of those 3,300, let's say, there were 0 civil monetary penalties that were levied by the federal government. The next year, there was only 3,773 out of compliance, and there were 2 civil monetary penalties. And then the following years is when things really ramped up. There's 15,400 hospitals that were found out of compliance, but only 12 were levied with civil monetary penalties. Last year, last full year, there were 14,600 out of compliance, only 3 civil monetary penalties. And through the half of 2025, there were 3,240 that were found out of compliance, and there were 10 civil monetary penalties levied. The point that I'm trying to make is that I'll share with this. Last year, when we were sitting here, my hospital CEO from CRMC had received a letter from CMS telling them that their website was out of compliance. And their software program had already fixed it, but they were out of compliance because the header for their transparency, for their portal, was at the bottom of the page instead of the top of the page. What I can gather from this data is that of those 15,400 that were found out of compliance, it was for small ticky-tack things that didn't rise to the fact that they weren't really doing what they were supposed to be. And so what I would say is I'm not really concerned about the fines and the civil monetary penalties, but we do have that in place. But what I was also say is to be found out of compliance because your header's in the wrong place, it really doesn't amount to hill of beans, and it doesn't change anything. What we have offered to do, and our members have talked about this, we plan on building a hyperlink for every hospital in the state on our website so that consumers can go right to the Wyoming Hospital website and then have hyperlinks right to every hospital so they can shop this. We're serious about being compliant and working with the legislature. And I know I've given you a lot of information. I probably bored the crap out of you, and I apologize for that. But I think it's important to know that we want to be good partners and that we want our consumers to be informed. I do have 2 quick answers though. Representative Wasserberger, ER does not count. And if you're having a heart attack, I don't think anybody cares what it's going to cost to save your life when you get to the emergency room or having a stroke. And Representative Clouston, the behavioral hospitals and the rehab hospitals are included already under federal, and they're already compliant. Actually, one of our hospitals that is in one of those realms received a notice about a month ago, and it was the same stuff. They had little things that were already tweaked by the time that they received the notice from CMS. And with that, do you have anything you want to add?
No, I would just add briefly, Eric mentioned that we do want to be a good partner with price transparency, and we are fully supportive of this. You could even, it's not fully built out, but we have been working on what he talked about with the platform. So if any of you were to take your phones out right now, we do have a link called Price Point or Price Check, where you can look at prices from various different hospitals throughout the state on our website already right now. So that is being done. Like I said, we are fully supportive of this.
Thank you. Committee, any questions of Mr. Boley or Ms. Prestistator? Yeah. Okay, seeing none.
Thank you.
Thank you for joining us. Any further public comment? Anybody online? No. Okay. All right, with that, I will close public comment on Senate File 57. Oh, we do have some more. Okay. Good morning. Welcome. If you'd state your name, we'll hear your take on the bill.
Good morning, Madam Chairman. My name is Raymond Red with Blue Cross Blue Shield of Wyoming.
Morning, Madam Chairman. My name's Dirk Dykestel. I'm with Blue Cross Blue Shield of Wyoming as well.
So we weren't planning on getting up today, but we appreciate the opportunity to do so. We did sit in on discussion on this bill on the other side of the chamber, and we felt it was important to get up and just clarify a few of the things that Mr. Boley had said. We've talked with Mr. Boley about these issues before, and I mentioned to him, you know, We understand that you're bringing bills, but when insurance is raised, I think we need to clarify this. And I recognize that Mr. Bully's not an attorney, so I suppose we can give him a pass for that. But health insurance companies, with respect to the Affordable Care Act, have had a transparency bill for just as long as the hospitals have. And the difference between the transparency bills that we must follow and the hospitals must follow is they have 300 services that they must provide. We have to provide our entire transparency file that includes all of our reimbursement, all of our cost share, all of the things that we are required to do. So it's actually a very wider requirement on the federal side for the health insurance companies to be more transparent about all of the things and the reimbursement that they provide. And then also on the hospital transparency files, there's also an allowed amount that is listed there that, you know, talks about exactly what the insurance carrier is reimbursing. So even on the hospital side, there's transparency with respect to what the insurance companies are providing to the hospital. The other thing I would say is that, you know, there has been a lot of legislation passed in this legislature in the last couple of years. We've had legislation on prior authorization requirements that Mr. Boley brought and the Hospital Association brought. And he was talking about all of the requirements that the hospitals have to, you know, go through with the insurance companies. But we worked on that bill. He agreed that that was a good bill, and we passed that bill. So I'm not sure why that's still an issue. One of the reasons why there was a lot of discussion was that that bill would lower cost. But what I hear a lot is the Hospital Association coming up here and talking about how costs are still too high. So I think maybe we should talk about a little bit how the different bills that have been passed have actually reduced costs, because we've agreed to prior authorization, credentialing requirements, no takebacks after 2 years. We've agreed to a lot in the last couple of years, and I think it would be important for this legislature to ask the hospitals to measure the cost savings that they've received from that as they continue to propose additional bills that they indicate will save costs. Because what we could provide to you is all of the additional costs that those bills have put upon our members and upon ourselves in order to provide health insurance. And of course, in the public space, there's a lot of discussion about how high premiums are. And I think that we need to understand why those premiums are so high if there's all this additional legislation. Another thing that Mr. Boley has said many times is that the hospitals are required to serve two masters, to follow federal and state law. All of the state law legislation that's been passed and been supported by the Hospital Association is already been codified in federal law. This committee is likely to get an additional bill that talks about speeding up the medical necessity determination, and that is already codified in federal law. There's already a requirement for us to meet certain timelines. So in passing this legislation, we're doing exactly what Mr. Boley says is not a good idea, which is to create conflicting federal and conflicting state law. And he's already done that, or asked this committee and asked many people in this legislature to do that exact thing on the insurance companies. Another thing that Mr. Boley indicated is that the insurance companies are the ones that are going in and checking these transparency files and using it as a way to push down the reimbursement. The one thing that I will say is that we have gone in and looked at these machine readable files, and the one thing that we notice and that we like to look at is there's the amount that we allow. So there's the billed amount, there's the amount that the insurance company allows to go to the provider, and then there's a cash pay amount that they accept, and we look at the difference between those two. So on many different things, a mammogram is an example. The allowed amount is about $40 more than the cash pay price that a hospital will accept. But if you start looking at other things like imaging, labs, pharmacy, things like that, you're talking about hundreds and hundreds and hundreds of percentages higher for when you compare cash pay to what they get reimbursed by the insurance company. Not just what they bill, but what they actually get reimbursed by the insurance company is hundreds and hundreds and hundreds of times higher than what they would accept as a cash payment. So I understand getting up here and talking about stories and anecdotal things, but we have data that indicates the things that we use those machine readable files for. And I do think it's important. But I would also say that to come up here and to say that the insurance companies don't have the same requirement is not correct and not accurate at all. And if anything, we have actually a much broader requirement and not just transparency. We have anti-gag clauses that were passed by the ACA that do not allow us to hold back any data. We also have transparency things on our provider files that require us to list all of the different providers that we're contracted with and all of the services that they provide. So if anything, we have way more requirements on transparency than the hospitals do. And we can have that discussion, but to get up here and say that the insurance companies don't have those same requirements is not accurate.
Madam Chairman, members of the committee, I would just also add that affordability is top of mind right now. We saw premiums increase, and those are largely and overwhelmingly driven by medical costs. And we want to be good partners. And frankly, with this bill, I think transparency is a very positive direction to go. We want to have shoppable services, not necessarily like Representative Wasserberger mentioned. When you are in an emergency situation, obviously price is not a consideration. But when there is something that you can, take a look around and see whether it is a hospital that can provide that service or maybe a physician's office that can provide that service, that is something that informed choice by consumers helps overall. And if we are really going to look at affordability and wanting to see how not only can healthcare provide quality service, access to service, but also affordable services, this is something that is absolutely needs to be a paramount priority. I'll close with also just saying, access to care is extremely important, and we want to have physicians' offices, we want to have medical care available in every community. But if it's unaffordable, it doesn't really matter if someone can't walk in the door and afford the services. So this is a step in the right direction.
Thank you. Committee, any questions? Representative Clauston.
Thank you, Madam Chair. Thank you, gentlemen, for being here. And first of all, I just want to thank you for the last few years and summers working on the task force, trying to make the bills better for Wyoming. The affordability in Wyoming is a problem for all of us. One of my favorite books is Row the Boat. I think we're all gonna have to row that boat this summer. So one of my interim topics is how do we make healthcare in Wyoming more affordable? And you guys are a big part of that. So, I'm gonna challenge you guys if you can bring us some ideas from your point that you think will help with affordability in Wyoming. I'm also gonna ask if, in the past, this committee has done some field trips, which has been really beneficial to us and informative. Like, would your company be amenable to us coming to see what it would like to be in your office? Is there some data that you could provide for us? Just questions on, would you be open to bringing some ideas this summer to help with affordability? And then think about maybe some type of field trip if the committee was open to that.
Mr. Red.
Madam Chairman, Representative Clauston, we absolutely would be. We've been having discussions with other legislators on this topic as well. And I know that you have been highly active in this, and we also appreciate that. We understand that, we have a legislature that understands the issues. We have legislators that live in this community, that understand this community, and the challenges that we face as a rural state. So we would be very happy to do that. And another thing that I've talked to Mr. Boley about many times
Mr.
is-
Red, I'm gonna pause you there.
Yeah.
I want to hear what you have to say, and forgive me for not addressing this earlier as the chairman, and Mr. Boley as well. But in our rules of decorum, we prohibit any testimony that personally calls out another committee member or somebody that has testified by name. So if you'd like to address the comment or push back against previous testimony, I would just advise you to maybe use, say, the association or the association that oversees hospitals, but please avoid personal names. Thank you, Mr. Red. Please continue.
Thank you, Madam Chairman, and my apologies for doing that. And I do apologize. So sorry, I did not mean to be offensive in any way, and I do apologize. So that is my mistake, and I will take that, not just for this meeting, but for the future. So thank you very much. one of the things that we've discussed with others that have been in the task force and have had discussions about is coming together and having a discussion about things that will benefit the whole ecosystem, as opposed to just one particular part of that ecosystem. Because as we continue to focus on just one aspect of it, the pressure mounts so high that it becomes unsustainable. And we are concerned that we're getting to a place where the pressure has become so high that it's becoming unsustainable. So we've shared data, and I think that at times it's been difficult to hear about, say, the cost of a drug, $500,000. The bill that we receive from a provider is $1.9 million. That's a discrepancy that I think we need to address. But I could get up here and give all kinds of examples like that. But what we're looking to do, truthfully, is to come up with solutions that can benefit the entire ecosystem. And when we have discussions about this internally, I mean that seriously. But one of the difficulties that we have is addressing not only the legislation that's been passed recently, legislation that's currently on the table to be discussed, and what we've heard will be discussed in addition to that already is fairly one-sided legislation. And so what we would like to do is exactly what you're talking about. And it is to really get together and talk about solutions that will benefit the entire state of Wyoming, including the providers that live and work here, and including the insurance companies that have employees that live and work here. Because there has been testimony given about hospitals going out of business and hospitals not having money. Well, there was a health carrier that just had to exit the market and reduces the ability of competition in the state. And their public testimony or their public address when they had to leave the market was not, this Blue Cross pushed us out of the market or somebody else pushed us out of the market. They said that the cost to be in Wyoming is too high and that they cannot be here because the cost is too high. That's what they said. So I think those are the issues that we need to be thinking about. And I appreciate the opportunity to respond to that question, Representative Clausen.
Committee, any further questions? Okay. Seeing none, thank you, gentlemen, for joining us. Any additional public comment? All right, seeing none, I'm going to close public comment. Committee, what is your pleasure on Senate File 23?
Move the bill.
The bill has been moved by Representative Wasserberger. Second by Representative Gugemas. Forgive me, not Senate File 23, Senate File 57. It's a Friday. Discussion committee on the bill. Amendments on the bill. Representative Yen.
Madam Chairman, I'll move the LSO technical correction amendment that was provided to us, which was page 1, line 7, adding, providing a sunset date.
Okay, we have a motion. Second by Representative Wasserberger. Mr. Caldwell, do you have that? Okay, Representative Yen.
Madam Chairman, it was sent to us by Ms. Johnson, and I will forward it to LSL, to Clayton. I believe it is in our email. It came in at 9:28 a.m. No, sorry, it came in yesterday at 4:55 p.m.
If you just said it,
I'll send it. And Madam Chairman, so the amendment is, again, it's just a technical correction from our LSO staff that was about, because there was a sunset date put in by the other side, they just didn't fix the actual title, so it just fixes the title for that.
Thank you. And I have that in front of me as well. Forward to Mr. Caldwell. All right, committee, is there any discussion on the amendment? Okay. Seeing none by a voice vote and a show of hands, all those in favor of Representative Yen's amendment, please state aye.
Aye.
All opposed? Okay, that amendment has passed. Further amendments on the bill? Any further discussion or questions? Okay, question being called by Representative Gugamas. Mr. Caldwell, if you call the roll on Senate File 57.
This is a roll call vote for Senate File 57 as amended. Representative Clouston,
Aye.
Representative Guggenmoss,
Aye.
Representative Heft, Representative McCann, Representative Ottman,
Aye.
Representative Thayer,
Aye.
Representative Wasserberger,
Aye.
Representative Yen.
Aye.
Chairman Rodriguez Williams. Madam Chairman, that is 9 ayes.
Okay, Senate File 57 has passed committee. Senator Brennan, if you would pick a co-sponsor to carry that on the floor, that'd be great. All right, with no further business in our committee, our meeting is adjourned. Everybody have a great weekend.